And here comes the defense attorney, polished, confident, and already setting the stage. Notice how he immediately jumps to bond issues? That's no accident. In high-stakes cases, the first battle isn't guilt or innocence. It's freedom while awaiting trial.
Your Honor, Joe Simon on behalf of Mr. Chang, making his way to the podium. State your name, Thomas.
Thomas Chang.
Thank you.
Your Honor, first things first, the court has my substitution.
That was a question?
Yes.
I do. Yes.
Thank you, Your Honor. And secondly, the request that I'm going to make is contingent on we want to address bond. That's okay?
Sure.
Your Honor, I told Ms. Grosso I'm requesting only a 10% privilege. I'm not going to request a bond reduction at this time. My client's 22 years of age, has no prior criminal history. His bond is currently set as $200,000 cash or surety. I understand I wasn't at the arraignment, but the safety of the victim was an expressed concern by the people, as well as his possible risk of flight. I can tell Your Honor that my client is a United States citizen. There's some information that his family resides in Saudi Arabia, and that is his permanent address. Well, that is true, and it's also not true at the same time. But he's a United States citizen who has a residence here. That is his full-time residence. Your Honor, I'm only asking for a 10% privilege.
Translation. Instead of paying the full $200,000, the defense wants the family to cough up just $20,000 cash. It's a classic move. Shave off the financial sting while still promising accountability. But judges know this game. The real question, does a lower upfront cost make it too easy for a defendant to skip town?
Because the bond could have been posted. The problem with the surety bond, as the court knows, is that the family or others who post it lose that money permanently. And if it were to be a 10% privilege, the family, assuming someone complies with their conditions, will get it back, less 10% for administration. And that is our request. Now, my client's family is here. They came from Saudi Arabia. His parents are here today in the front row, as well as his uncle who lives locally. The complainant and my client do not live together. They do not attend the same university. As I understand, she's a student at the Eastern Michigan University. My client's University of Michigan student. They do not reside together. They have no reason to have contact. And my client would abide by that. So in other words, Your Honor, my request isn't yet this time to try to lower the bond, but simply to the court allow to a 10% privilege. Again, the surety.
But the surety, I mean, if we're really, just to be blunt about it, if we're really talking dollar amount, I understand what you're indicating to the court. But if it's a 10%, who's pledging the additional amount?
Well, there wouldn't be an additional if it's 10%. So, and it
Well,
surety.
there would
And
be.
are you asking?
210%. Somebody is not pledging it, but somebody's going to promise to pay the $200,000.
Oh yeah, that'd be my client's parents. I'm sorry, I misunderstood your court's question. And you're right, Your Honor. There's just two differences on a surety. Surety is the number one difference is the court would be holding $200,000 for the pendency of the case. At the end of the case, it would be returning $200,000, but the person who paid the surety would be out $20,000 permanently. In this case, my client's parents would post the $20,000 if the court permitted a 10% privilege, and they would be responsible.
I mean, I understand the argument, Mr. Simon, but I mean, again, to the extent a dollar figure to secure the defendant's presence is necessary, it almost seems to me that one might get to a $2 million 10%.
Oh, Your Honor, my client has ties here. He's retained client counsel.
I'm just saying, I'm just talking in terms of the argument
Esoterically?
regarding the amount.
Oh,
That's all I'm saying. To the extent that the $200,000 is the amount that needs to be secured.
yeah. And frankly, I think that's a very high bond, but I don't think it would ever be higher. And here's why. Here's why. My client's guidelines on his worst scoring, if we go best to worst, are a straddle cell. He can be secured here by turning a passport over, but his also to indicate his mother is going to stay here during the pendency of the case. And his father's trying to relocate his job back to an office here in the state of Michigan. I mean, they're invested in terms of his flight risk.
This is where things get strategic. The defense paints a picture of roots and stability. Mom staying in town, dad moving jobs, passports handed over. But will that outweigh the prosecution's looming story of violence? Stay tuned, because what comes next flips the mood entirely.
There are ways to ensure he won't be a flight risk. There are also other ways to ensure safety, that he's willing to abide by any condition that I've seen the court impose before in cases like this.
Respond.
Your Honor, the reason that we asked for $250,000 in this case was because the defendant and the victim have been dating for 2 years. They were together on the date in question in the living room having an argument because the defendant accused the victim of cheating. He got on top of her, held her down with both of his hands, releasing his left hand, and grabbing her by the neck, strangling her, causing her to struggle to breathe to the extent that she felt dizzy. He was able to speak, but the defendant cut her off and said, "It's your fault." He then got off of her. They separated for a moment, but he asked her to go to the bathroom to smoke some weed. She agreed, went into the bathroom, strangled her again. At that point, he cornered her in the bathroom, yelled at her to stop acting like that. And
Whoa, let's pause here. Did you catch that? Not once, not twice, but 3 separate strangulations, one causing blackout. This isn't just an argument gone wrong. This is sustained violence, control, and terror. In legal terms, that's not just bad optics, that's aggravation, and it screams danger to the victim.
strangled her to the point where she couldn't breathe. She tried to push him off, went into the bedroom to get her belongings. And then at that point, she saw the defendant had her phone and was going through her phone, and she tried to get it back. He made her promise that she loved him and wouldn't call her cousin or 911. At that point, he pushed her onto the bed and went into the bathroom with her phone. She followed, trying to get her phone back because she's obviously terrified in this situation. He told her to get on her hands and knees and beg for forgiveness. When she refused and stood up and tried to leave, he strangled her again, a third time, from behind, pulling her backwards. He started dragging her from the bathroom to the bedroom and threw her onto the bed. She couldn't breathe. She blacked out. She couldn't speak. She tried to get her phone back because he still had it at this time. And at that point, he again reiterated that she needed to promise him that she loved him and that she wouldn't call him. Continued to push her down, to pin her down. And it was only after an extended period of time and she threw a water bottle at him that she was able to get her phone back and call. But it went on for an extended period, including 3 separate instances of strangulation, one causing her to feel dizzy, one to the point where she actually blacked out. This was a prolonged, continued period of violence, and we have significant concerns for the victim's safety.
Your Honor, can I respond? I agree that a lot of those facts are in the police report, but I also have to supplement. First of all, if those allegations are made, that doesn't mean they're true. They're represented as that is what happened in this case, and we have absolutely defenses to those things. I will say this because I don't think it's proper to litigate a case at a bond motion, but I can say this, that I agree that after—
I'll tell you what, I'm going to need a written motion.
Notice the judge stepping in? This is Courtroom Management 101. Judges hate when bond hearings spiral into mini-trials. The key here, evidence battles happen later. Today's issue is strictly about money and safety.
If you can get it to me today, I'll hear this afternoon, but I can't stop the docket to go through this in this entirety this morning. I will be more than happy to set you today at 3 o'clock to listen to this in its entirety.
Your Honor, may we approach? And I'll be happy to do what the court asks, but may we approach?
Yes.
Thanks.
What you were doing? All right. Okay. Are we bringing Chang up? Court calls the case of the people versus Thomas Chang.
Your Honor, Joe Simon on behalf of Thomas Chang. State your name again, Thomas.
My name is Thomas Chang.
All right. Where are we on this?
Your Honor, first of all, appreciate you allowing us to come back on the docket. Your Honor, this morning I started by saying I didn't want to make a bond reduction motion and instead was requesting a 10% privilege. And I think that technically that probably is a reduction in a sense. But I didn't want to make a bond reduction motion because I'm just coming up to speed on the case and I didn't want to go into all the detail, et cetera. There's videos to go through, et cetera. So if the court is going to, I've already made my piece on my request for the 10%. If the court is going to deny that request, then we're just going to ask the court to set a PCC date out a little bit. Dare I say that date of the 13th would work well. But if the court would grant the request, that's
All day.
My client's parents are here and prepared to do whatever the eventuality happens.
Any additional information?
Nothing further here.
All right. The court, in listening to the argument on the case and reviewing the file, because I was also trying to get as much information as I could from the original arraignment and the like, which I had not reviewed or looked at or in any way processed. But in looking at that, the court would not believe that 10% privilege on this particular bond, given the circumstances of this case at this time, would be appropriate, or find that the magistrate in any way abused their discretion in doing so. So the motion for that modification.
And there it is, denied. The judge basically says, nice try, but the risk is too high. It's a reminder. Bond isn't a right. It's a balancing act between freedom and safety. And in cases with this kind of violence, safety usually wins.
Is denied.
Thank you, Your Honor. I do want to know if the court could possibly give me a copy of the pretrial release order as it stands, because I don't even have that. If I can get that.
The release.
Or that, sorry, the boss.
Yeah, it's generally it's a domestic violence conditional release.
Okay,
But that's fine. You need an actual copy of the.
if I could.
We can take care of that.
Thank you very much. And
What
then,
date would you like it set for? The 13th?
I understand there's a docket going on the 13th.
Why?
I understand there's a docket going on the 13th, Your Honor.
There is.
That would be
It was
great.
supposed to be limited for me, but it's apparently not doing that now because of Simon. So I will set probable cause in this matter for August 13th, 2024, 9 a.m. or as your invite indicates.
Thank you, Your Honor.
All right. Bond will continue. Thank you.
Thank you, Your Honor.
That heating. That right there.